Good afternoon and welcome. My name is Banaz Mansouri. I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides low-cost representation and free advice and counsel to people in Washington state who have been denied unemployment benefits or whose award of benefits is being challenged. We're here today with our weekly webinar, which occurs every Monday at noon. We thank you for joining us. The purpose of today's webinar is to share the latest news on unemployment benefits, provide information about a recently filed lawsuit, and answer your questions. We'll share commonly asked questions, and I will also be monitoring the questions in the Q&A chat box today. We'll also be providing resources through our chat box. I'd like to introduce our speakers from the Unemployment Law Project. Joining us is John Tierpak, Executive Director, and Ann Paxton, Staff Attorney. I'll now turn it over to Ann to get us started.
Thanks, Banaz, and welcome everyone to our weekly webinar. We have been following the format of launching right into what is the latest news because there's a lot happening every week in terms of unemployment benefits payments in Washington State, and going through some frequently asked questions, and then turning the floor over to the audience to see if you have any questions. So please feel free to add questions to are you using the Q&A or the Q&A? Yeah, please do that. And Banaz will either stop me to ask the question or we'll save them till the end. So the big news from Thursday is that the job search requirement, which was scheduled to expire July 1, has been extended to August 1st. This is sort of a suspenseful moment every few weeks because we don't know whether the job search requirement is going to be continued to be suspended. But the legislature agreed with the governor that this was important, so it will now. That means that the job search requirement is not in effect right now, but it will towards the end of the month. The Employment Security Department is scheduled to start asking people again for their job search details. So keeping track of your job search log and being ready to report on those will become important in 3 or 4 weeks. And as we always like to mention, it doesn't hurt to look for a job anyway. But to not be too surprised when you are asked about job search. But for right now, it's technically suspended until August 1st. So
calls and questions about what constitutes a job search, and people say it's ridiculous.
John.
Why am I searching for work when I can't there are no jobs in the field? Just make the applications, send a resume or fill out an application, and only apply for work that is suitable for you, that it would be safe for you to do based on your condition. Because if there is a job search requirement, your only requirement is to search and make job contacts for jobs that are suitable for you.
Great. Thank you, John. So we've also received a lot of questions about the status of our petition for writ of mandamus, which was filed about a month ago. And it was filed by the Sheridan Law Firm, and we are an interested party along with a couple of claimants who have been subjected to undue delay in having their benefits, in receiving their benefits. So the latest is we've asked for an accelerated review by the state Supreme Court. We're hoping to hear from them soon. There has been an answer from the Attorney General's office, so that suit is proceeding. We're hoping to see something happen soon. John, do you want to give any other update on that?
Well, just a little update and background in that these are very unusual procedures. It's not a class action suit. It's basically an action to get Employment Security Department to promptly process claims and make payments. They've been not processing claims or making payments since March, but since the fraud investigation in May, their promise to do a prompt investigation and then restart benefits has not been kept. So thousands of people all over the state are waiting for benefits. People who've already provided their ID, even multiple times, are still waiting. So we're getting declarations that can be submitted with the case with future filings. We've already submitted some with the Sheridan law firm, sending them with the court filing. So if you or someone you know has been subject to undue delays for reasons due to the fraud check or for other reasons, please contact Unemployment Law Project, or I can put my email in the chat. You can email me personally to sign up. We are getting hundreds of people calling. Our office gets about 1,000 phone calls a week. So there may be a delay getting back to you, but if you do want to participate, that would be helpful.
Thanks, John. So the big question from ESD's standpoint right now, and for a lot of people in the state, is what to do when the an employer you worked for before the COVID pandemic hit requests that you return to work. What conditions would be considered important in making the decision to return? So as most people understand, in order to collect unemployment benefits, it's pretty generally required, except in very few exceptions under COVID, that you be available to work. So refusing an offer of suitable work is potentially grounds for a denial of benefits or even an overpayment. So it's very critical to have a good understanding of what is going to be requested if you decide that you don't feel it's safe enough to return to work. The Department of Labor has just issued a very extensive list of considerations that employers should take into account when they're trying to make the workplace safe under COVID-19 conditions. So it includes issues about cloth face coverings, sanitization, cleaning and disinfection, what kinds of safety training is required, social distancing, and so on. And I think Benas has that link, so she'll put it up on the chat line for anyone to look at. So that has got quite extensive details on what needs to be covered. But also I want to mention that the state has issued general requirements and prevention ideas for workplaces that here the Labor and Industries Department has said employers should comply with. So it's not only, you cannot discriminate against people who have any kinds of risks related to COVID. In addition, there's mandatory social distancing. There have to be frequent and adequate hand washing required. There has to be routine and frequent sanitization and so on. So that is available at, can you copy that link down? It's on the left. Okay, and then I'll put that in the chat just in case you would like to consult that. But they have stressed many times, frequently, that if you have a general fear related to COVID, it will be difficult for you to make the case that you are not returning to work because of a safety risk. You want to have specific grounds for saying that it's your workplace would put you at risk. Perhaps you have a family member at home that is a high risk person that can't afford to be exposed to COVID. Perhaps you're aware that the employer is not complying with certain safety requirements. As specific as you can be, that's what you want to consider to be prepared for if you're going to decline an offer of a return to work. So there's no magic words, they say, but essentially the magic words are a specific safety violation or lack of safety or some other high risk category that makes you have more than just a generalized fear about exposure. John, do you want to add anything to that?
Can I jump in real quick? I'm
Yeah.
sorry. And the link that we provided, I clicked on it and it's going to an error message on the OSHA website. So if you have an updated link, send that over to me and I'll get it up to the chat.
Okay, good.
Thank you. Sorry, John, go ahead.
Well, so if general fear or...
John, there's something wrong with your sound.
Okay.
There it is.
So general fear might not be good cause, but many people have post-traumatic stress, anxiety issues that are severe medical issues and psychological issues that need to be addressed. So if somebody just says, well, if it's fear, if it's more than that, if it's a medical issue, I would advise people to not go back to work and maybe to get some medical documentation from either your medical doctor or a psychologist saying why that would be unfit for you.
Okay, thank you. So another question that has risen is whether there are any extended benefits available beyond PEUC. So you may remember that PEUC, Pandemic Emergency Unemployment Compensation, is the extension to regular benefits that have been expired. So they could have been expired as early as last July. But if you applied for PEUC, you can get an additional 13 weeks of benefits, just like regular benefits, under the CARES Act. That's a provision of the CARES Act. So when those expire, what happens? That the state has triggered into a status that allows us to have what's called extended benefits, which is a special category under federal law, which allows the state, if they hit a certain unemployment level, to offer extended benefits. But the trick here is that extended benefits have somewhat more onerous conditions than regular extensions of benefits under the current law, such as under PEUC. So they come with very strict job search requirements that are different from regular benefits job search requirements, and the consequences for failing to meet them are rather severe. So you can get up to 20 weeks, but your job search, if there isn't work in your field, will have to be extended to other work that you are able to, that you have the skills and abilities to do. If the gross weekly pay is greater than your weekly benefit amount, then technically that would create the expectation that you accept the work. It must pay at least the minimum wage in your area, but there are some kinds of work you don't have to accept. If the position is vacant due to a labor dispute, working conditions are less favorable than similar work in your labor market. That could be a very strong possibility under the COVID pandemic. Or if you'd be required to join or resign from a union. So that's 20 extra weeks with a big asterisk, extended benefits. You can get technically up to 59 weeks of unemployment, but there are going to be some new conditions when extended benefits kick in. Another question that's come up is about the furloughs of state government workers. Many of you have heard that most workers have been asked to take 1 day a week furlough in order to get the state budget under control, since there's a huge decline in revenues and a lot of additional expenses being faced. Until the legislature allocates more money for the state, these furloughs have been considered necessary. So how are they going to affect unemployment benefits? One fortunate thing is, especially because ESD is dealing with such a huge backlog, is that ESD personnel are not subject to the furlough. So they will be continuing, even though we feel they're very understaffed, and we've seen the evidence of that, they will be continuing at the same work levels that they've been at. The unfortunate thing is the Office of Administrative Hearings, which handles appeals of denials or appeals of or challenges of benefits on the part of employers, they have been furloughed. So it's our understanding that every Thursday they're going to not be available for phone service and presumably for handling appeals, hearings as well, which is extremely unfortunate because we think that there is a huge backlog of appeals pending at the Employment Security Department, and they've been sort of log jammed because ESD says it's hoping to manage a lot of them through the redetermination process in-house rather than sending them to OAH. This is kind of unfortunate because we found OAH in the past has been fairly quick at handling appeals. That always depends on how many are coming in. But we would like to see that those sent straight away over to the OAH, and we'll see what happens then, given that there's a furlough at OAH.
So with this policy of employment security not sending hearing requests to the hearing office, we've talked to people who've been waiting for months who have requested hearings, and recently a clerk at the hearing office said they are scheduling, they are getting hearings requests about 7 weeks late from the hearing from the Employment Security Department. So it's a pretty outrageous violation of due process. It is unconstitutional, and it's something that must stop because people cannot wait months. The ban on evictions will be expiring soon, and so they they should be processing claims. So I would urge you, if you're waiting for a hearing and you're not getting it, I would urge you to call your state senator and your state representatives about that as well.
Thank you. Just one second. Okay, one other question on this slide was about some claimants' accounts being frozen. There's been quite a lot of press about this, particularly at Chase Bank, suddenly and with no notice, freezing certain customers' accounts, allegedly on issues related to fraud at ESD, but there's been no clear confirmation from ESD that it's even related to anything happening with their unemployment benefits account. So this has been a serious concern to a lot of people who've contacted us. We have been in touch with the Employment Security Department about this, and the commissioner has said she has requested that people contact her directly if they've been frozen, their account's been frozen, because apparently there are some mixed signals that are being exchanged. We don't know exactly how, but the federal agencies may have been triggering these account freezing processes, and perhaps ESD did not intend for them to happen that way. But they say, ESD says that they will address these in the cases where they determine that there's not fraud. So that is what they're telling us, but to contact her directly. So you can reach her at slevine@esd.wa.gov. And Benos, maybe you can put that down. About the issue of freezing of accounts. So this is an issue this next issue is one that's been kind of really plaguing us for several weeks, and that is what happens when you appeal a denial of regular benefits, but you may be eligible for benefits under the federal program, the PUA. Do you have to wait until the appeal is resolved? And this is really a dilemma for us because we are advising people or helping them with their appeals. And we want to be sure that we're not at the same time blocking them from receiving benefits they could be receiving under the PUA. So we've asked the ESD about this, and they have said, if you apply for PUA, it's not a problem, it doesn't affect your appeal, and it should not be affected itself by your appeal. So apparently these are separate processes. They say that they will consider the application for PUA, and that the appeal will not affect it. The only wrinkle is that if you have a low benefit, you could be affected by this because there is a small difference between the PUA benefit and regular benefits. So if it turns out that you should be actually getting regular benefits, you win your appeal, should be getting regular benefits, and you have been receiving PUA, then you may have to pay back it's not a large amount, but there is a small difference. It would not make so much difference if your benefit amount is larger. But just something to keep in mind, that you might have an overpayment, but it doesn't appear to be hugely significant. This is something you would want to get in touch with us and we can at least give you some advice on it. And then finally, can I get credit for my 12 weeks of standby when the job requirement is reinstated? We've been told that if you have been utilizing the suspension of the job search requirement, which everyone is eligible for, and you have been on standby with your regular job, that you still can tap into those 12 weeks when the suspension of the job search requirement runs out. So right now that's not going to happen until August 1st. But evidently after August 1st, you would still be able to tap into the freedom not to search for a job under your standby status if you have that, and continue expecting that you would return to that same employer. Any comment on that, John, on standby? Your sound is
standby. Sound better or worse? Does it sound okay? So with the whole standby situation and the suspension of the job search, it's created a lot of confusion, and it was a moot point from March until now, since the job search was suspended, whether you were on standby or not. But if that, if the job search requirement is reinstated, then it will make a difference being on standby or not.
okay. So just one other thing I wanted to mention, I pointed out the L&I requirements for employers to make a safe workplace. This is the chart that I like to point people to, because it does answer a lot of questions about what you qualify for under regular benefits versus COVID-19 pandemic related benefits. So in the short version is, if you are unemployed, partially unemployed, or unavailable to work because of a COVID-related reason, then you can receive PUA benefits. So all of that is still continuing until the end of the year. The thing that will expire is the PUC, which is the extra $600. Right now, that is expected to expire at the end of July. So there's only a few more weeks of that left. And that ends the frequently asked questions that we had been receiving. So I'd like to turn it over to audience questions at this point.
Great. Thanks, Anne. Let's stick with the PUA issue. We have a participant whose PUA was approved and paid for 7 weeks. Then when her UI application was being reviewed and went into adjudication, her PUA payments were stopped, and now they show as pending. So now no benefits are being received from the state, and she's been out of work since April. They, looks like she filed an appeal for unemployment benefits, and that appeal paperwork was received on July 3rd. So what should she do? 1, probably to get her PUA benefits back online, and 2, what's the turnaround time for hearing dates for UI?
The turnaround time for hearing dates is unfortunately extremely long. We are hearing about very few appeals actually arriving at the Office of Administrative Hearings. They are they're laying off certain judges. They're furloughing employees. We are not receiving the volume of appeals that we would expect. Even we're just close to our regular low level of unemployment number of appeals. So we're very puzzled. We're very concerned that these appeals are getting caught up in adjudication process, which can be a very bogged down process at ESD. John, do you have any comment on that?
Yes. So a couple of things people can do. One is they can contact their state senator and state representative. I will put the link in the chat in terms of finding your district. I would urge you to write and call them, email them and call them, all 3. And if they don't respond, email and call them again, because they have the ability to contact the unemployment office for you to advocate that your claim be fixed. Also, if you want to make a witness statement for the court case in Olympia, contact me. I put my name and my email in the chat. So contact me and you can make a statement. Some of the people who have made statements already have had their claims fixed, because I think the Employment Security Department is trying to fight the case by fixing claims to prevent further embarrassment. So you can contact me to make the witness statement, but also contact your state senator and state representatives.
Great. On a similar note, we have a participant whose initial claim paperwork was denied. She's self-employed. This was back in mid-May. She's reached out via messaging through ESD to get assistance to get her PUA application processed and start receiving benefits. She's sort of left in this void. Any suggestions on what she can do other than continuing to message ESD through the SAW account?
Well, again, state senators, state representatives, also contact King 5 News, Cairo 7, Como, whatever local news, whether it be like Seattle Times, whatever your local newspapers are. Also, contact us to see if you want to be a part of the court case. Also, I put the email in the chat for Susan Levine of ESD. Sending her a message may or may not get a response.
Yeah, I would strongly recommend trying to contact the press. That might be a very effective way. At least it's something most of us can do. You never know when you're going to strike the right chord and the right day when they have a deadline and they need a good story. So I would not give up on that, even though they're hard to reach sometimes.
Okay, great. We also have, again, still same on the PUA issue. We have a claimant who was denied UI. She's unable to work because she's a single mother taking care of a third grade child. The type of work that she's suitable for is not conducive to remote work or telework. And so she has applied for PUA. She was denied PUA and is now awaiting. She just received the denial recently after waiting 7 to 8 weeks to receive the decision on June 30th. Is it your advice that she appeal?
Yes, appeal definitely, and also contact your state senator and state representatives to see if they can intervene to have the appeal actually processed.
Okay, great. If someone has realized that they made an error on their UI or PUA claim filings, what's the best way for them to go about correcting this error prior to having received a determination from ESD?
So the user interface with the ESD through the online system is a little opaque to a lot of us. We don't have direct access in many ways. I've heard that it's very difficult to make a change. John, what do you hear about doing that?
Well, if you can reach somebody, the problem is even when you reach someone, they often say you're at the wrong level. They need to send you to another level. Again, calling your state senator, your state representatives, emailing them has been helpful for some people to get a more personal response. And if that doesn't work, I would urge you to contact the Speaker of the House, Lori Jenkins, or the Chair of the Labor Committee, Mike Sells.
Great. I would also add to that, it's helpful to go back and look at all of your past letters from ESD in your messages in your SAW account. There may be some indication of what information is lacking, and maybe they perhaps give you a link or another opportunity to provide additional information. Sometimes these letters, well, often these letters tend to be very wordy and convoluted, and we just tend to skip over a lot of the information that's in them. So we strongly encourage everyone to go back and thoroughly read every word of every letter ESD sends, no matter how conflicting the message is. There may be a nugget of information that could guide you back towards how to provide them additional information and sort of get you out of this waiting pattern. Okay, so the follow-up to that is that if there's a mistake in the claim and she cannot clarify with them, then it seems negligent on the part of ESD. And so is there any other sort of legal action or other action that can be taken to draw attention to ESD's negligence and the resulting harm?
So we do have the lawsuit that we're involved in. And as I mentioned, it's not a class, John mentioned, it's not a class action, although we're taking declarations from people. So we are working on that. I think it's, I have heard about individuals filing suit. John, there was one, I think that our attorney at the Sheridan Law Group mentioned. Did you know anything about that?
Well, people have filed individual claims. There's another person who filed their own writ in the Supreme Court, but people can file claims against ESD. You can contact your local bar association. I put in the chat the website for the Washington Employment Lawyers Association. You can do individual lawsuits against ESD. Let's see, so Washington Employment Lawyers Association is at welalaw.org, WELALAW.org. There's a member directory. You can look for lawyers who may be interested. Also, depending on what county you're in, you can contact like the King County Bar Association, Spokane County Bar Association, or if you're in a smaller county with a smaller population, maybe look into a neighboring county and contact attorneys who would be interested, because you can sue them for negligence, but that would include also damages, not only getting your benefits fixed, but any harms that were caused by their actions. And I've talked to many people who've had their cars repossessed, other harm to their credit, other issues like that have been quite serious.
Okay, great. That's all the questions we have in the Q&A. There are no additional questions. If anyone has additional questions, please pop them in the Q&A box and we'll be sure to answer them.
Also, I just put in the website for the King County Bar Association, kcba.org. But there are bar associations around the state that have referral panels for attorneys.
I can give you one other press contact. Michelle Lee at King 5 is mli@king5.com. She's always interested in stories, so give it a shot if you think you'd like some press coverage.
Right, and I just dropped that in.
I did too. You beat me too.
Okay.
Okay, we have one other question.
Sure.
I've lost hours, but I'm still employed. I was denied UI based on, quote, not answering a question. They don't state what question that was or where it was asked. Should I still apply for PUA?
Lost hours, I'm not sure what that means.
Well,
I wonder if their hours were reduced.
Here's
Okay.
always the question. If you're back to work, there's a formula as far as what your income is. So if you're back to work and your income is more than you would get on unemployment for your base amount, then you are not eligible for benefits for that week. So if you're back to work and if it's a solid job with a higher income, even if your hours are reduced, you probably won't get benefits. But if it's a lower income, or if it's fluctuating hours and income, you may be eligible week by week, depending. So it's kind of an individual question. You'd be welcome to contact me about it, but it's the kind of thing where going back to work means different things for different people. It could be a minimum wage job, or it could be a job that pays $50, $60, $80 an hour. So unemployment regular benefits cap out at $790 a week. So if your income was above that, although there's a formula Ann can try to explain, it's not exactly dollar for dollar, you may be able to get some benefits. And again, that 600 is going to go away soon.
Yeah, so the formula is a little opaque and I won't go into it, but roughly you can calculate it yourself. Just take 75% of the income that you're bringing in that you're going to need to report to ESD on your weekly claim. 75% of that subtracted from your benefit, and if that's below zero, you won't get any benefit that week. It's important to it's say if the average benefit is $450. So John mentioned the top benefit $790. That's for people who are a little bit higher income. The average benefit in the state is $450. That means if you're bringing, if you go out and earn some extra money, if you earn $600 that week, roughly $600, you will not get any benefit that week. So 75% of your amount that you earn has to be deducted from your benefit. And you can find the exact numbers at the earnings deduction page. Oh, Benas, maybe you can look that up. I didn't write it down. At the earnings deduction page at the esd.wa.gov website.
One thing I've been advising people who are very concerned about claiming benefits for a week they might not be eligible, and people are worried about, are they committing fraud if they're applying? And so my answer is very clear: just relax, just provide accurate information. So doing that complex characterization, if your weekly benefit amount was $400 and you make $405 or $420 or $480, you don't have to worry about calculating for that week. You just provide correct information of what income was earned in that week, whether you were paid or not, and also income before any taxes are taken out. That way they will do the calculation and you don't have to worry about it. I've been advising people not to close down their claim week by week because reopening a claim can be a pain. So it's better if you're in a fluctuating income situation to keep the claim open and report. Some weeks you might get money, some weeks you won't, but that way you can simply report once a week.
And one other thing to mention is if you even have $1 of benefit left after the deduction, you will still qualify for the PUC, $600 until the end of July.
Great. We have a retirement question. How does ESD treat retirement income both from Washington state and from out of state? Our participant was told by an ESD agent that ESD only looks at in-state pensions, but that does not sound right to him. So what's the information we can provide?
I've never heard of in-state versus out-of-state as a rule. I would have to go back to the rules and look at that. My understanding is the issue whether receiving a pension is deductible or counts against your unemployment is whether it's an employer paid pension. And generally what they do is if you receive, let's say, $1,000 a month, they would prorate that over 4 weeks and deduct that amount according to a calculation from your weekly benefit. I think it's crazy, by the way. It makes no sense why income that you earned years ago would somehow count against as current income, but that's the way the law is badly written right now.
Right. Okay. We have a participant who is over 65, has diabetes, and is on remission from cancer and works in self-employment. Do they have to currently look for work?
Well, the current rule is no, but after the August 1st, it will be yes. But they should only look for work that is suitable for them under their current conditions. And I think that is easy to do. If you want to contact me directly, we can give more of a consultation, but there are ways you can look for work and make those 3 job contacts in a way that won't put you at risk of either losing benefits or causing yourself harm for health reasons or otherwise, because the rule is you must be looking for suitable work, and what is suitable for you is not suitable for someone else, and there are jobs that are suitable for you.
So all of this is new territory because the Employment Security Department has never paid benefits to people who were self-employed before this, except under a special program. But in general, no. Now, but what you do need to demonstrate is that you're actively looking for clients, not necessarily a job. But if you are self-employed, you have to show that you're open for business, you're available, you're marketing, you're not just passively collecting benefits. That's what they want you to demonstrate.
If a participant wants to apply for PEUC, what claim restart date would they use?
So PEUC should kick in when your benefits, your regular benefits are exhausted. So normally that would be 26 weeks under regular circumstances. So you can date that from the time your claim started. That's when it should kick in.
Date that from the original claim start date?
Yes, your regular benefits.
Okay, great. We don't have any more questions right now.
Okay.
So if anyone has additional questions, please throw it in the Q&A. Okay, do you have to apply for the pandemic emergency compensation $600 a week? Or is it automatic?
So we understand that that's automatic. It should go, if you get regular benefits or PUA, that should be automatically tacked on. And if you're not receiving it, please let us know. We'd like to hear about an exception to that because we've been telling people that that's what they should expect.
Okay, great. No other questions at the moment. Anyone have a question? Throw it up.
But we'll be back next week if you want to ask questions.
Thank
then.
you very much, everyone. And again, feel free to, this is a public event, but feel free to contact us individually at Unemployment Law Project, or just call our office either here in Seattle or in Spokane, or send us an email, whether through our website or through an email posted here. We are open, and many of these questions are very personal and should be more of a private consultation.
Okay, but we do have two other questions if we have some time.
Sure.
Great. We have a participant who was placed on standby. Their company is offering to bring them back into another position because the company is restructuring. Must they take the position? And if they don't, will they lose their unemployment benefits?
So the first question to always take into account is that you are expected to accept an offer of work if it's suitable work. So that means in line with your qualifications, your experience, and your past jobs. So that's the first thing to take into account. John? Anything?
Well, I would also like to add, of course, be careful of the location, be careful of any health issues or safety issues, but also there's a bigger question here for a lot of people in their careers, and it's something to consider. A lot of people are offered work to come back at less pay or less hours, and maybe they can argue and maybe they can turn that down and keep getting unemployment. But for some people, depending on the situation, accepting that may be a better choice right now, since unemployment won't run forever. And also that employer may increase hours at a later time, and it may be good for you to get back to work. I've talked to people who are eager to get back to work and love their jobs and are willing to take a cut. Others hated their jobs to begin with and are eager to get out. But it's easy to say, I'm not going to go back because my pay is cut, or hours are cut 30 or 40%. And get unemployment, but you have to look to the future. What are your other job prospects right now? And for some fields, that may be hard to do, hard to find a new job right now. So all of these factors should be weighed before making any decisions.
Great. We have a participant whose PUA claim was fixed on June 14th. They didn't realize this till July 1st. And while they're grateful, all of their claims since then have now been disqualified with no reason given. What's our...
This is a very common question. I've talked to many people in the last few weeks in this situation. Again, normally if there's a problem with unemployment, I would say request the hearing. But people are not giving notices of hearing, and even when they do request a hearing, hearings are not being processed. The hearing requests are not being processed. So again, I go back to call your senator, call your state representatives, contact King 5 News. It's outrageous that people have to put up with this.
Mm-hmm. Great, thank you. No additional questions right now. Anyone else have any more questions? Maybe we'll wait another minute or so to see if any pop up. Again, you can check our chat box for a number of links for media, for ESD sites, and also ULP staff to contact. We host these webinars weekly. You can find us here. You can also reach out to any of us individually or to our office for specific questions. Any takers, any questions?
I think we're done.
We're done.
Okay.
Thank you,
Thank
everyone,
you,
for
everyone.
participating. We look forward to seeing you next week.
Thank you.
We will be back next week. Thank you.